Alternative dispute resolution, simply explained, is a method for avoiding formal litigation in court proceedings. When two or more parties have a dispute that needs to be settled, a form of ADR can be used to help guide the process. Three basic forms of ADR include negotiation, mediation, and arbitration. Negotiation is just what it sounds like. It can be as simple as sitting down together and getting to the bottom of an issue. For example, a plumber on a service call may have left a valve open underneath the kitchen cabinet. The resulting flood is the fault of the plumber. Instead of suing the plumber in court, the client could simply ask the plumber to pay for the repairs, damages, and anything else that they may negotiate for. If this seems like a good solution to both parties, then the dispute is resolved. Attorneys could be used in this case, and that may be a good idea to help formalize the negotiation with a contract of some sort, but negotiations can also be completed and executed without the help of an attorney. Another form of alternative dispute resolution is mediation. Mediation involves the participation of a neutral third party called, not surprisingly, a mediator. The mediator will discuss details with both parties individually and also jointly. The mediator will help the parties to see any commonalities or points of agreement. This will help the parties to evaluate their options. Mediators may also suggest solutions, but the mediator doesn't make a decision resolving the matter. Instead, a mediator's proposal can be used to help the parties decide how to settle. Mediation has the advantage over traditional litigation in that parties don't generally become as diametrically opposed as they do during traditional litigation. This is valuable in the cases of employers and employees, business partners, and other people who wish to maintain an ongoing relationship after the dispute. The last form of alternative dispute resolution I'll discuss is arbitration. This is another option to avoid formal court proceedings, though it most closely models traditional litigation. In arbitration, parties present opening arguments and ask for remedies. Evidence and witnesses are also presented for consideration. The main difference in arbitration from the other two forms of ADR that we have discussed is that the final decision is actually made by the arbitrator. Arbitration is often legally binding, meaning that, like it or not, the arbitrator's word is usually the final say, barring some kind of misconduct during the arbitration process.
Created using Powtoon.